Education and Development team uses the recordings for quality assurance. Please note that the recording will not be made available to the attendees. So if you could please make your own notes because the recording will not be made available. So the time is 2 minutes past 10 according to my clock, and we are now starting with day 2 of Pension Law 2022. Today we're going to be dealing with the distribution of death benefits. I'd like to just remind you of some of the housekeeping rules that we went through yesterday. Please ensure that you keep your microphone muted so that there isn't any distraction for the entire team. Please feel free to ask any question whenever you want to ask a question or to bring in a comment. To do that, because I will be presenting, please simply unmute your mic and state your name, and you can come in then with your question or your comment. Please remember at the end of the session that we will be sending out evaluation forms. Please take the time to complete that for us. We'd really appreciate that. It helps us improve the quality of the session and how we deliver it to you. I think that's about it. I'm going to start projecting the presentation now. Can you see my presentation?
Yes, we can.
Thank you. All right, so now when we started the pension law webinar yesterday, before we went into divorce orders, we started by having a quick high-level view of the different types of retirement funds. We looked at what is a pension fund versus a provident fund, and I also touched on retirement annuity funds and preservation funds. So today we look at the different types of death benefits that may be paid by a retirement fund. So it's important to understand what type of benefit is being paid so that you can advise your client properly. So a death benefit may be payable in the form of a lump sum. And in some instances, the benefit is not a lump sum, right? So if it's not a lump sum, you know, that's where it may be a spouse's pension or a child's pension that is being paid by the fund. So if it's a spouse's or child's pension, if it's an ongoing benefit that is being paid by the fund, it's important to refer to the fund's registered rules to understand the terms and conditions applicable to that benefit. So quite often you find that with a child's pension, if the parent of the child is the deceased member and the child qualifies for that pension, then there would be a certain point in time where the benefit would cease. So normally that's the point where the child attains age of majority. Now, when that benefit ceases, there would be nothing further to be paid to the child. Some fund rules allow for continuation of a child's pension beyond the age of majority. And there are different rules that apply to that. So in some instances, the benefit may be extended up until such time that the child completes their tertiary education. And in some instances, if the child is disabled, then the benefit continues for the life of the child. So it's important to look at the rules of the fund and understand. I think there's someone whose mic is not muted.
I'm trying to mute them, Andrew.
Thank you. Thanks, Ntombi. So where you have a child's pension or a spouse's pension being paid by the fund, it's important to look at the rules, see what the rules provide, so that you can advise your clients accordingly. In many instances, you find that with a spouse's pension, there may be more than one spouse. And if that's the case, then the rules will provide what should happen then in relation to that spouse's pension. How should it be paid? To whom should the benefit be paid? And how the benefit will be calculated. But for purposes of this presentation today, we are not looking into those types of death benefits, i.e. the child's pension or the spouse's pension, because those are normally straightforward. The rules will provide how the benefit must be dealt with, and the rules are binding on the fund itself and the member or any beneficiary who's claiming a benefit under the rules. So you don't really find a lot of problems with those types of benefits. What you would normally find problems with would be the lump sum benefit that is payable by a fund. Now, before I go into the lump sum benefit, my apologies, before I go into the lump sum benefit payable by a retirement fund, I have to also mention that there are also different types of lump sum benefits that become paid in the event of the death of a member. Now, in some instances, you find that there's a lump sum being paid by the retirement fund itself, and that is what we will be talking about today. In other instances, you may find that there is a lump sum benefit being paid by the insurer. Now, if the member is employed and he is a member of a pension or provident fund by virtue of his employment, in some instances, the employer would also have a group life policy for its employees, and that would pay out in the event of the death of an employee. So we call those benefits unapproved death benefits. Why do we say unapproved? We say it's unapproved because any benefit that becomes paid by a retirement fund is an approved benefit because the fund has been approved by SARS, by the commissioner at SARS for tax. So if it's not a benefit being paid out of the fund or through the fund, then it's unapproved because it doesn't come through this entity that is approved for tax, right? So in the case of these unapproved benefits where the insurer is paying that benefit upon the death of the member, what you will normally find is that the policy document governs the terms and conditions of that cover. Once again, it is normally straightforward and it does not bring any complexity. So the member is required to nominate a person or persons to receive the death benefit in the event of his death. And in the event that he or she nominates more than one person, they can also set out the portions of the benefit that they wish for each nominee to receive. And in the event of death, the insurer will be guided by that nomination of beneficiary form. So the insurer will pay the benefit directly to the nominated beneficiaries, and the insurer will pay exactly in the manner specified by the member. And that makes the unapproved benefits a typically clean exercise to go through to process. If there's any dispute or doubt, we all go back to the provisions of the policy document. If there's any dispute in relation to nominees and beneficiaries, we go back to the members' nomination of beneficiary form. So that is also not what we're covering today, but I just wanted to mention that, you know, there are different types of benefits that could be applicable. So it's important when advising clients to check what kind of a benefit is it. Is it a lump sum, or is it an ongoing payment being paid as a spouse's or child's pension from the fund? And if it is a lump sum, is it approved or is it unapproved? And to determine that, you would need to just simply identify who is paying the benefit. Is it being paid by the insurer, in which case it's unapproved, or is it being paid by the fund, in which case the benefit would be approved? Okay. So to the last point appearing at the bottom of the screen, so a spouse's or a child's pension is not regulated by Section 37C of the Pension Funds Act, but it's regulated by the registered rules of the fund. And that's because the wording used in Section 37C of the Pension Funds Act specifically excludes any benefit payable as a pension to the spouse or the child of the deceased member. Now, the section in the Pension Funds Act that regulates the payment of death benefits is Section 37C, that's 37 capital C of the Act. And in terms of 37C, a death benefit payable by a retirement fund as a lump sum does not form part of the deceased member's estate. Now, that is something that's extremely important to note. We receive quite a lot of letters from attorneys where they represent people who are dissatisfied with perhaps the distribution of a death benefit by the fund. And, you know, my observation is that quite often the attorneys miss that provision within Section 37C of the Act, and it's in the opening lines of Section 37C, where it specifically says that that death benefit shall not form part of the deceased member's estate. So you may have the deceased's will, in terms of which, you know, he or she has identified certain people and nominated them to inherit from his estate. But in the event that you're dealing with a distribution of a death benefit under Section 37C, that would not be binding on the fund, because the fund is the entity that is authorized in terms of 37C to distribute that death benefit. So it's not payable to the estate. Now, there are 6 scenarios that we need to consider as set out in Section 37C of the Pension Funds Act. The first scenario is that if the fund is distributing a death benefit, if it becomes aware, if it identifies one or more dependents, then the fund will have to pay that death benefit to those dependents. If it's only one person who qualifies as a dependent, then the fund will pay the benefit to that person only. If it's more than one dependent, then the fund will have to make an equitable distribution of the death benefit. Now, before I go on, I have to also say that, you know, the word equitable, when we say that the fund must make an equitable distribution, it doesn't mean that it must be an equal distribution. So you may be dealing with the distribution of a death benefit where the deceased was the breadwinner and a parent, and this deceased person has 2 children. Let's say there's 2 children, one is a major, one is a minor. Now, they are both children of the deceased. You know, they are equal before the law. You know, both share the same parents and all of that. So no one is trying to discriminate between the two children. But when the Act says you have to make an equitable distribution of the death benefit, it means you have to take into account the personal circumstances of each person and make an allocation that is equitable given their personal circumstances. Now, that is where quite often we have problems with the distribution of death benefits. So we have two children, one is a major, one is a minor, and the fund decides to distribute the benefit on a 70-30 basis. So in that case, you know, the trustees could decide that they want to allocate 70% of the death benefit to the minor child and only 30 to the major child. Now, the major child may be dissatisfied with that decision because in their view, we are both the children of the deceased, we are both financially dependent, it should be split 50-50. So the reason the trustees would not distribute the benefit in that manner, i.e. on a 50-50 basis, is that they would have to consider the personal circumstances of those identified dependents. In the next slide, I'll talk about, you know, who's a dependent, how do we determine whether you're a dependent or a nominee. But for purposes of this slide, I just want to set out these 6 scenarios, i.e. that if you have a dependent, you pay only to that dependent. If you have more than one dependent, then you make an equitable distribution to those dependents. If you have one nominee only, then you pay per the nomination form that was completed by the deceased member. But in that case, Section 37C requires that the fund can only make the payment after expiry of a 12-month period from the date of the deceased's death. Now, the reason they put in this requirement that the fund must wait for 12 months is that Section 37C is seen to serve a social purpose. So it serves a social purpose in that, you know, the legislature recognized that the socio-economic circumstances of people in South Africa are different to the rest of the world, right? We have people who have children born out of wedlock. We have people who are financially supporting other people who are not their blood relatives, right? Or in some cases, it's not close family. You know, some people, you know, there's that sense of community, you know, at times with people where you may find that someone, you know, decided to take in their friend's child, you know, and they are living with this child and the child is financially dependent on them. So the purpose of this benefit is to replace that financial support that was lost by those who are financially dependent on the deceased as a result of the deceased's death, right? I mean, we have the Road Accident Fund, which pays out benefits to the dependents of people who were the breadwinners, who were taking care of them financially and who lost their lives in motor vehicle accidents. So even from a Section 37C point of view, the intention, and this is why there is so much emphasis on dependency, or financial dependency, it's because it is intended to replace that financial support that was lost by reason of the deceased's death. So with this emphasis on financial dependency in mind, it then became important that, if we have a nominee only, and if that nominee does not qualify as a dependent, we should say that the retirement fund should wait for at least 12 months before they pay that nominee that entire benefit. And the reason is to allow a reasonable time for a person who was financially dependent to come forward and submit his or her claim so that they could also be considered in the distribution of the death benefit. So we don't want to pay a nominee the benefit in a rush and only, end up prejudicing the dependents who have lost financial support due to the deceased's death. The next scenario is where you have more than one nominee. Once again, you pay in terms of the nomination form. And if you have dependents and nominees, then you make an equitable distribution of the death benefit. And you have no dependents. If you have no dependents and no nominees, then only in that case can the death benefit be paid to the estate of the deceased member. So we first look at whether there are dependents and or nominees. If we cannot find any dependents and or nominees, then we pay the death benefit to the deceased estate. And once again, that would be after expiry of a 12-month period. If the deceased does not have an estate that has been reported to the Master of the High Court, then in that case, that death benefit may be transferred into an unclaimed benefit fund if it has remained unclaimed and unpaid for a period of 24 months from the deceased's death. So we're speaking of dependents and we're also speaking of nominees when distributing this death benefit, right? Now, who qualifies as a dependent? Now, in Section 1 of the Pension Funds Act, the Act specifically defines dependent, and it provides that dependent in relation to a member. Now, it goes on to give you different categories. It says that it means A person in respect of whom the member is legally liable for maintenance. Now, under category A of dependent, it is understood to mean that this person in respect of whom the member is legally liable for maintenance would be someone who has a maintenance order against the member. So someone who presents a maintenance order irrespective of the relationship between this person and the member would qualify as a dependent on the basis that they have a maintenance order, right? Remember, as I mentioned before, big emphasis on dependency. So someone with a maintenance order is dependent on the member for their maintenance. Under the second category, paragraph B, it provides a person in respect of whom the member is not legally liable for maintenance, meaning that there is no maintenance order. If such person was Roman numeral 1, in the opinion of the board, upon the death of the member, in fact dependent on the member for maintenance. Now, under B1, we're talking about someone who does not have a maintenance order, but that person can prove that they were in fact financially dependent on the member. Now, that person would qualify as a dependent under paragraph B1, and B2 is if that person is the spouse of the member, so there must be marriage, you must qualify as a spouse. And under the third category, if that person is a child of the member, including a posthumous child, an adopted child, and a child born out of wedlock. So that's category B, right? It gives you, it has its 3 subcategories, and it talks about someone who was factually dependent, a spouse, and a child. And then under paragraph C of the definition, it refers to a person in respect of whom the member would have become legally liable for maintenance had the member not died. Now, once again, this paragraph does not refer to the relationship or the degree of relation between the member and the claimant. It's just talking about this person would have become legally liable. This person would have been entitled to maintenance had the member not died. So in some instances, you find that the parent of the deceased member would qualify to be seen as a dependent under this paragraph C of the definition of dependent, because they are able to prove that, their financial position changed at some point. So even though they were not in fact financially dependent on the deceased, but they would have been financially dependent had the deceased not died. And they would adduce evidence around things like the nature of their relationship, that they were on good terms with the deceased. Had they been financially destitute, the deceased would have, in fact, had no problem supporting them financially, and that the deceased, had the means to actually provide that support to them. So before I move on from this definition of dependent, I just want to also highlight something else under the second category, paragraph B2 of the definition of dependent. So they refer to a spouse of the member. Now, we all understand a spouse to be someone who is married, right? But in the Pension Funds Act, there's a specific definition for spouse under Section 1. And that definition provides that spouse means a person who is the permanent life partner or spouse or civil union partner of a member in accordance with the Marriage Act, the Recognition of Customary Marriages Act, or the Civil Union Act, or the tenets of a religion. So, meaning that when we refer to a spouse, it would also include a life partner, and it would also include someone who was married to the deceased in terms of the tenets of a religion. So going back to the discussion we had yesterday when looking at divorce claims, I made the point that it is difficult at the moment, given the current legislation, for retirement funds to pay divorce claims if people were married in terms of the tenets of a religion, and in cases where the parties were cohabiting. It's difficult because you wouldn't have a court order. So in any case where there is no decree of divorce granted in terms of Section 78A of the Divorce Act, then the pension fund cannot pay a divorce claim, because then there is no pension interest that can be calculated by the fund. But when we deal with death claims, you can see now that there is a bit of a shift. So suddenly we're including a life partner. A life partner now qualifies as a spouse under the Act. And now we're also including people who are married in terms of the tenets of a religion. I think that's something worth noting. It's important when we...
Mr. Matibi?
Yes, sir.
It's Albert Marais. I asked the question whether this Section 37C includes a spouse married out of community of property, and then there's a viewpoint from Ms. Smart that the duty of support between spouses exists whether one is married in or out of community of property irrespective. But my question is specifically, what does Section 37C say about a spouse married out of community of property? Thanks.
Thank you. Thank you. So Section 37C does not, differentiate or draw any distinction, in terms of the marital regime at play. So and this is why I think it's important to consider the fact that it is so broad that the word spouse even includes a life partner, meaning that these people are not married, right? They're not married, but they have this relationship that is akin to a marriage. So it is a relationship between the two of them, and there's that reciprocal duty that is at play between the two parties. I don't want to say that it's a relationship exclusive of all others, because that's like the traditional definition of a marriage. But we know that in the current social setting in South Africa, there are people who are in more than one relationship at the same time. There are people who are legally married to more than one person at the same time, right? Which is possible in terms of the Recognition of Customary Marriages Act. But what's important is to look at the nature of the relationship between the two people, the deceased member and the claimant. And what's also important to note about this definition of dependent in Section 37C is that when you look at a person who would qualify as a factual dependent under paragraph B1, it does not even need to be someone who, in terms of common law, would have a claim for maintenance against the member. So meaning that any person who can actually prove that there was some financial support that they were receiving from the deceased would qualify as a dependent. Now, that in itself, given how far-reaching it may be, it shows you that even in relation to spouses, it does not mean that when we look at that relationship between the deceased and the claimant, that we consider the duty to support each other. It's not so much about your financial arrangements. Do you have a single estate as parties have when they are married, in terms of a marriage in community of property, or do you have 3 estates as if you were married out of community of property with an accrual, or is it seen as 2 estates where you are married out of community of property with the exclusion of the accrual? So for 37C, it's just about, is there some evidence of financial support? And you will see that in many cases, in terms of people who bring their claims as spouses, you find that, and I've had a lot of debates with attorneys about this, you find that there is a person who's married to the deceased in terms of civil law, and they have a marriage certificate. That was the first marriage that the deceased may have entered, right? And after entering a civil marriage, you find that the deceased goes and marries someone else in terms of the Recognition of Customary Marriages Act. So in that case, he enters into an African customary marriage, right? That being the second marriage. And there may be subsequent marriages after that too. But you find that the first spouse to be married would present this argument to say that in terms of our law, bigamy is still a crime. In terms of our law, you are still not allowed to enter into more than one marriage at a time if you are married in terms of civil law. right? In terms of the, in terms of a civil marriage. Now, the argument being presented by the spouse would be to say, because I was married first and I have this marriage certificate, this makes all other subsequent marriages invalid for as long as my marriage was still in place, because my marriage was not dissolved. Now, I think that I would agree with that argument in terms of talking about the civil marriage, in terms of talking about succession outside of 37C, outside of distribution of a death benefit being paid by a pension fund. Because for purposes of the fund, in a case like that where you have the civil spouse as the first person to be married, we are going to say that she qualifies as a dependent under paragraph B2 of this definition of dependent. And then for the other people who were married subsequent to her marriage, those people, even though they may not qualify under paragraph B2 of the definition here, but what you will normally find is that they actually received financial support from the deceased. And for that reason, they would also qualify as spouses under paragraph B1 of the definition of dependent. So the fact that, strictly speaking, those marriages are invalid does not negate that they still qualify for a claim because they are dependents under a different subparagraph in the definition of dependent. And I think I can just extend this point to also say that even with children, we find this quite often in practice that the spouse lodges a dispute saying that, why are you including some child that I don't know of in the distribution of this death benefit? I don't believe that's my husband's child. I've never heard of this child. My husband would not have a child outside of our marriage. And in that case, the spouses would want to take the fund to task and say, before you include this child in the distribution of this benefit, you must prove to me that this is in fact a child of the deceased member, right? Now, in a case like that, without insisting that the child must undergo paternity tests and all of that, the fund can simply still consider that child as a child of the deceased if the child qualifies under paragraph A of the definition of dependent, meaning that you find that there is a maintenance order that was obtained in favor of the child against the deceased member while he was still alive. Alternatively, where the deceased was providing financial support to the child, even without a maintenance order, in which case that child would qualify as a dependent under paragraph B1 of that definition of dependent. Does that help, Albert?
Absolutely. Thank you very much.
Thank you. My apologies. I must say again that I'm not able to see hands, and I also cannot see any text that's put on the chat. If we have time at the end of the presentation, we can go through anything that's put in the chat. But I do encourage you to ask your questions as we go along so that we can make the session interactive as it was yesterday, and we can all learn from each other through the interaction.
Mr. Motivi, Masika here.
Hi, Masika.
Yes, I am concerned about the monies, the reserves that will be in the beneficiary's pot, in that you mentioned that when the beneficiary turns 18, or depending on the circumstances, whether they are at tertiary or not, then the fund will continue to provide maintenance for them when they are at tertiary up until to the age of 25. Now, when what happens to, surely the time when they're making payments, there is money and then they pay a certain amount to the child, to the child. So when the child attains the age of 18 and the child becomes independent, or the child is at tertiary, but for some reasons they drop out, what happens to the reserves that will be in their in their pots? Thank you.
All right, Masika. So your question is, if the benefit is not paid to the child up until such time that they complete their tertiary qualification, what happens to that money? So just so that we don't create any confusion for anyone. So we're stepping away from Section 37C for a moment, right? We're going back to that explanation I provided at the start of the session today, where I was talking about a child's pension. So what I said is that in some cases, a pension fund could be paying a child's pension in terms of its rules. And in those cases, you need to look at the rules of the fund to understand the terms and conditions applicable to that benefit, because that benefit would be regulated by the fund's rules, right? Now, you're asking what happens to the money if for some reason the benefit terminates early. So normally a fund that would provide a child's pension would be what we call a defined benefit fund. Now a defined benefit fund is a fund that is built on an actuarial model. You can think of it in simpler terms, something similar to a medical scheme. So there's an actuarial basis to look at how much money needs to be put in the fund by the members, and to also to determine the benefits that should be paid by the fund. So that child's pension that becomes paid on the death of the member is not in fact something similar to a defined contribution benefit. So we have two types of retirement funds, pension funds, in fact, let me put it that way. The pension fund may be a defined contribution or defined benefit. With a defined benefit, there is this actuarial model on which the fund is built, and the rules of the fund provide that when you are a member of the fund, this will be the benefit that you receive when you retire. So when you exit, the rules prescribe what benefit you will get. The benefit is defined in terms of the rules. With a defined contribution fund, on the other hand, the rules only define the contribution that you pay in. So it works quite similarly to a bank account. The rules tell you this is how much must come in as a contribution. You pay that in during your membership, and by the time you exit, the benefit that will be paid by the fund will be all of the contributions paid in, less expenses, plus growth on those contributions. So that works more like a bank account. So you have an expectation to say, I've put in 100 Rand times 10, that's 1,000 Rand. The contributions are 200, the fees or charges, the expenses are 200 Rand. So it's 1,000 Rand less 200 Rand plus growth of another 200 Rand, that's 1,000 Rand. And that's your expectation as to what you must get out. But from that defined benefit fund, only the benefit is defined, not what you put in. So when the rules say that the benefit ceases upon a certain event, i.e. The child becoming a major, if the rules say the benefit ceases, you cannot insist that the benefit should continue on the basis that you have paid for it. you cannot insist on the basis that the member put in contributions, you know, for so many years. He worked for 10 years contributing to the fund, and now you've paid a child's pension only for 3 years, therefore you must pay out more. It wouldn't work like that because there's an actuarial basis for that fund. There's also a lot of cross-subsidization that happens within that. It's a complex structure. For me personally, I'm a lawyer. I don't find it easy to understand those things. But you know, the rules are clear in terms of the benefits that are payable. So normally, even within a fund like that, in addition to that child's pension or that spouse's pension, you may find that there is also a lump sum amount that becomes payable by the fund in terms of Section 37C. And I'm bringing that in with the hope that you know, it will give you some comfort, because it sounds to me like where you're coming from is that you're thinking that if a person works for many years and contributes into the fund, then it wouldn't make sense for the only benefit to be paid out to be a child's pension, and that also ceases immediately when the child attains age of maturity. So there is normally a lump sum benefit payable in addition to that child's pension or the spouse's pension that gets paid. And normally with the spouse's pension, that gets paid for the life of the spouse. So for as long as the spouse is alive, the fund would continue to pay that pension to them, and it would only cease upon the spouse's death. I hope that helps, Masika.
Sorry, Mr. Matipi, I've got another question in relation to dependents in terms of Section 37C benefits. Does a spouse, for example, have to actually be dependent in order to claim? Let's say the spouse is working, earning his or her own salary and not in fact dependent on the deceased member. Would he or she still be entitled to a claim?
Thank you for that. That's a good question. From a Section 37C point of view, and I'm going to touch on this in the next few slides. So the first part, or the first step in the distribution of a death benefit, step 1 of 3, is that we must identify who qualifies as a dependent, right? And then we must also identify those who were nominated to receive the death benefit. That's step 1. Once you've identified all of these people, now you have you know, your list of people who are potential beneficiaries. Now the next step is that you are supposed to now allocate the death benefit in an equitable manner, right? Now, in allocating the benefit in an equitable manner, that's where we're going to look at each person that we identified, including that spouse. And we're going to apply a number of factors to come to an equitable distribution of the death benefit. So you know, I think we can get into more detail around that in the next slide or two, but just to answer your question for now, the answer is, if a spouse was not financially dependent, they qualify as a dependent. However, that does not necessarily mean that they will receive the death benefit. So for purposes of this exercise, there is no person who is guaranteed to receive a portion of the benefit. The outcome will depend on the second step, where we are allocating the death benefit, and we are applying the factors that we are required to apply. Is that satisfactory?
Yes, thank you.
Good morning, Marai here. I also would like to have to just find clarity on this. So in other words, if a dependent wishes to claim, do they need a judgment in their favor? Do they need to have approached court determining that they are dependent? and the reason why I'm asking is specifically in with consideration of that 1-year case recently that actually has in the minority decision the implication that any form of dependence and a reciprocal duty as such for purposes of maintenance could extend to parents, etc., as well of the deceased.
Yeah.
So my question is basically, is it up to the fund administrators to decide the equitable and reasonable distribution, or should at least some form of decision or judgment, or as I said, some finding in favor of the person who is claiming, is that required? I understand that when it comes down to, you know, divorce orders and deciding we've got to have a divorce order if the union is capable of being dissolved by a court order, then we know that is when it becomes applicable in relation to yesterday's seminar. But now, specifically considering that 1-year case, I would like to know how far does the fund or whoever go in their discretion to decide the so-called equitable division.
Yeah. So see it in this, and this is what makes Section 37C so interesting. Look at it as administrative action, right? The Act, Section 37C, empowers or authorizes the trustees of the fund to make this decision. And that's where the administrative action comes in. So the trustees look at, so there's an investigation that is performed. Once the fund is notified of the death of the member, there's an investigation that's performed. Normally, we start off by looking at the employee's records, the member's record, to see if he has at some point nominated people to receive his death benefit. Once, if we receive that, oh, I'm sorry, I thought I had someone speak. If we receive that nomination of beneficiary form, that's the starting point in terms of compiling our list of potential beneficiaries, right? Then we do some investigative work to find out where did the deceased live, who did he live with, to see if there could be someone who is not part of this nomination form. Now, once we've gathered all of that, the next step is to make an equitable allocation of the death benefit. Once we've allocated the death benefit, we notify the interested parties. And normally this is not a requirement by law, but it's industry practice. Normally the fund would send out that notification to the interested parties to say, this is how we intend to distribute the death benefit. Should you have any information that would warrant that we change this decision, then please come forward with that information. We're giving you X number of days. It may be 14, it may be 13, right? And once the trustees have done that, and you know whether they receive additional information and choose to disregard it, or perhaps there isn't any further submission, then the trustees go on to finalize their resolution in terms of the decision on the distribution of the death benefit. If any party is dissatisfied with that distribution decision, then that party would then be entitled to either lodge a complaint against the trustee decision with the Office of the Pension Funds Adjudicator. We normally encourage people to use that office for any complaint or issue that they have. We encourage people to do so because it's a free service. Unlike litigation, it's a free service. It's a statutory ombudsman. The people who work there are pension law experts. The pension funds adjudicator herself is a pension law expert. They are used to dealing with retirement fund matters. They understand the industry, they understand the law, and the decisions of the pension funds adjudicator are tantamount to an order of court. So we encourage people to use that avenue, but there is also the option to, lodge a review application, because this is administrative action. When the Board of Trustees exercise their discretion to distribute the death benefit, that is seen as administrative action. So you can ask for reasons if you were not provided with reasons for the decision, and you can then follow the process in terms of PAJA, right? In terms of the Promotion of Access to Justice Act. Now, the first part of the question that you're asking, in the earlier stage, where a person is lodging a claim saying, here I am, my name is Andrew TB, I wish to be considered as a dependent. I don't need to present a court order to the fund in order to be considered a dependent. All I need to do is to give them evidence that would show that I qualify under one of these categories set out here in the definition of dependent. So meaning that if I'm a category A dependent, it means I'm a person in respect of whom the deceased was legally liable to maintain. I would have to evidence that by presenting a maintenance order, right? If not, if I'm a category B dependent, then I would either, have to be B1, 2, or 3. If it's B1, I would have to show that I have proof that the deceased was financially supporting me. And, it's important that we also talk about this, that quite often in our industry, we find that people say, I was financially dependent. But once you say, prove it, then, you don't get satisfactory proof of that. And the fund is empowered to exercise its discretion. So in some cases, the fund may accept that a person was financially dependent without any bank statements that show transactions that the deceased was transferring money into their bank account. In some instances, the people will say, he used to give me cash, or he used to buy me things. Each month, the deceased would come to my house and deliver, food, groceries, things like that. But it's about whether the fund, the trustees are satisfied of that information that is presented to them. So in some cases, for those who don't have proof of financial dependency, they would get independent third parties, neighbors, colleagues, friends, to submit their written statements, whether it's a letter or an affidavit, to corroborate that version that is being presented by the claimant. And if it's well corroborated and it's supported by independent third parties, then the Board of Trustees may accept that as a fact. So that's for people who would be claiming to be dependents under paragraph B1. For those who are saying they are dependents under paragraph B2 as a spouse, then in that regard, you would have to advise on what basis are you saying you qualify as a spouse. If you're saying you were married, actually married, would like to see a copy of the marriage certificate. If you say that you were actually a life partner, we would like to see evidence of that life partnership. So bring us things such as proof of address to show that you lived in the same house with the deceased. Bring supporting statements by third parties, independent third parties who can confirm that you are known as a couple to them. Sometimes people bring in affidavits by their landlords. Sometimes they bring in evidence of, that they were sharing their bills. that they were renting a property, it was in both of their names, that they had nominated each other on their life policies, that type of information that paints a picture to show that these people were in a relationship that is akin to a marriage. So that's what we would be looking for under paragraph B2. And under B3, if you are saying you're a child of the member, then we would need to see that birth certificate for the child, and an unabridged birth certificate if this is a child and the member was a man, and any other evidence if there isn't a birth certificate that may support that. And under paragraph C, again, we would want that person to make submissions to show why they are claiming that they would have been legally liable, they would have been entitled to maintenance from the deceased had he not died. So I hope that answers your question, Marika, to say that at claim stage or at claim investigation stage, there isn't any hard and fast rules about what you must bring, but in order to prove that you qualify as a dependent, you need to satisfy us that you qualify under one of these categories, and you need to be able to support that with some evidence. I hope that answers your question.
Thank you very much. Excellent answer. Thank you.
Thank you. So now moving on. Sorry, before we move on, so we just went through the definition of dependent in terms of section 1 of the Pension Funds Act. And then the question that we normally have to deal with is that now how do you define a nominee? Because we're saying in terms of section 37C, we are going to consider dependents and nominees in the distribution of the death benefit. But who is a nominee if section 1 defines a dependent? So currently the Pension Funds Act does not define nominee, right? All we know is that a nominee is a person who would have been identified by the deceased member in the nomination of beneficiary form. So that person does not need to have any relationship with the deceased. They don't need to have been financially dependent on the deceased. They will simply be considered as a nominee on the basis that the deceased decided in his or her own mind that I want this person to receive a portion of my death benefit. So no one is to question, were you in a relationship? Are you siblings? Are you parent and child? That doesn't matter. As long as you are nominated, then you may be considered for the death benefit. And that presents some problems, and I'll touch on that in the next slide or two. So distribution of death benefits now, therefore, it means that there are 3 categories of dependents that exist. We have legal dependents, we have factual dependents, and future dependents, right? The legal dependents are those people in respect of whom there's a maintenance order, and also the child of the deceased and the spouse of the deceased, those relationships where we know that legally there's a duty to support such a person. The second category is factual dependents. Those are people who, are not legal dependents, but they were in fact financially dependent on the member for support. The third category is future dependents, and those are people who are saying, had it not been for the deceased death, in the future, I would have become dependent on him had he not died. And the question that arises is, does it matter which category of dependent a person is? Now, the answer is no. It doesn't matter. It doesn't matter because when we do a distribution of a death benefit, the first step is to identify who qualifies as a dependent and or a nominee. And in the second step, we are going to be allocating the death benefit in an equitable manner. So it doesn't matter what type of dependent you are. What's important will be how you score in the allocation step, which is step 2 of 3. The third step is determining the appropriate mode of payment, and that would be the final step in the distribution of a death benefit. So, as I mentioned, that a nominee is not defined in the Pension Funds Act. We also know that a retirement fund is not bound by the nomination of beneficiary form. So the trustees are not bound by that form that the member completed to say, I want this particular person to receive a portion or the entire death benefit. The trustees have a duty to investigate who qualifies as a dependent and who qualifies as a nominee, to allocate the death benefit in an equitable manner, and then pay that. So that the nomination of beneficiary form, some people have asked, why do we have it then? If trustees can simply ignore it, why does it exist? And the simple answer to that, a simple response, is that it exists because while it's not binding on the trustees, it's also seen to provide guidance. So it tells us who are the people that the deceased wanted to receive the benefit. And that is one of the factors that are considered when we make an equitable distribution. I'll touch on that shortly. We also know that a nominee may only be a natural person because Section 37C benefits serve a social purpose. So you cannot nominate a juristic person to receive a portion of the death benefit. You cannot nominate, an inanimate object or anything like that. It has to be a natural person. With the proposed changes to the Pension Funds Act in terms of the Conduct of Financial Institutions Bill, it is proposed that people should be allowed to nominate even non-natural persons, i.e. juristic persons, to receive a portion of their death benefits. So, people may then be allowed to nominate their favorite charity organization if they want to receive a portion of their death benefits. We also know that the nominee doesn't need to be related to the member, and they may not receive more than what the member allocated to them on the nomination form. We also know that for nominations that were made before 30 June 1989, those nominations will be seen as invalid if there is also a dependent identified. So that's set out in Section 37C of the Pension Funds Act. Now, going into the distribution of the death benefit. So we've mentioned that the fund or the trustees are to identify all the dependents and or the nominees. We've put together a list now of people who are potential beneficiaries, right? So the fund is charged with the duty to trace or to investigate. The language used in Section 37C is they refer to the trustees becoming aware of a dependent or a nominee. So it's the fund that is charged with the duty to investigate. In practice, however, the fund is allowed to say that, you know, we've done the best that we could in terms of investigating and identifying the potential claimants. We waited for a reasonable period before we could pay the benefit. But if a dependent comes forth, you know, after the distribution has taken place and that dependent was not considered because the trustees did not know of their existence, then, you know, the trustees can also rely on that to say, but there's also a failure to act on the part of this dependent in that, excuse me, in that he or she did not come forward while we were investigating and dealing with the distribution of the death benefit. But the primary or the general rule is that the trustees are the ones who are charged with the duty to investigate. So they cannot sit back and fold their arms and say that we're waiting for people to come forward and claim the benefit. They need to be proactive and do the investigation. The nomination of beneficiary form and the death claim application forms are normally a good place for the trustees to start their investigation process. With pension and provident funds, you know, you also look at the employer to see if there's any information that the employer can give you about the member. You know, before COVID-19, when everyone used to go to their place of work and not too many people were working from home. You know, people had relationships at work, they had friends at work, so you could talk to them, interview them, and find out more about the deceased as you're investigating that claim. So it's also excuse me, required for the trustees to exclude any person who does not qualify as a dependent or a nominee. The trustees are required to collect all the information that is relevant and to ignore irrelevant information. And to obtain written statements if necessary. So the Act doesn't prescribe that the information collected has to be in writing. So each fund determines, you know, through its own policy, how they want to receive the information. There was a practice prevalent, you know, a few years ago where boards of trustees would say they want affidavits. So all information must be presented on affidavit. And then there were also issues in that the trustees would rely on that information without testing the veracity of that information and then make a distribution decision. And only later, you know, when there are complaints, would they actually find out that they actually relied on incorrect information. And there was a PFA decision or determination a couple of years ago that spoke about that, which addressed the issue of reliance on information being presented on affidavit. That the fact that it is on affidavit does not necessarily mean that it is accurate. We all know that when you sign an affidavit as a commission of oaths, your job is to only satisfy yourself of the identity of the person deposing to the affidavit, right? It's not your job as commission of oaths to check the content of the affidavit, of the written statement itself, to ensure that it is accurate or correct. Your job is to only ensure that the person who's signing this affidavit as Mr. X is in fact Mr. X. He may be talking about, you know, he's president of the United States of America in the affidavit, but that's not for you to confirm as the commissioner of oaths. So for that reason, it's important that the board of trustees, when receiving this information, when considering this information, needs to test, you know, that it's correct and that it's accurate. In some cases, you find that there's a conflict. There are conflicting submissions being made. It's important that the trustees apply their mind to that and try to resolve that conflict and arrive at a proper conclusion. So once we've created this list of people who will qualify for the death benefit, we need to now start allocating the benefit, making that equitable distribution, right? Now, here we remember that we touched on the 6 scenarios earlier on. One of the 6 scenarios was where there is one dependent only. If we have one dependent only, we don't need to allocate the death benefit because we're paying the benefit to the dependent. If we have one nominee only and the member has nominated this person to receive 100% of the death benefit, we're paying that benefit to the nominee as set out by the member in his nomination of beneficiary form. If you have 2 or more nominees, you pay in terms of the nomination form once again. So those are instances where we don't have to do step 2. Those are instances where we don't have to be thinking about making an equitable distribution. However, if we find that we have 1 or more dependents and 1 or more nominees, or dependents only, then we need to make an equitable distribution. And this is where step 2 comes in, right? Now, we have to then consider the basket of factors. Excuse me. Now, when we refer to the basket of factors, you will not find the basket of factors anywhere in the Pension Funds Act, but this is something that was developed through case law. Apologies, I thought someone wanted to say something. All right, so the basket of factors are factors that were determined, that were established through case law. In the case of Setole versus ICS Provident Fund, the Setole case. I saw a comment yesterday. I think someone wanted a case citation. So if you want the citation for the Setole case, it's Setole versus ICS Provident Fund and another 2004 BPLR 430 PFA. So it's a PFA decision where the adjudicator said these are the factors that must be considered by a retirement fund when making an equitable distribution of a death benefit. So we have a list of people. We ask them a number of questions such as how old are you? How was your relationship with the deceased? How much do you earn? Are you employed? Are you self-employed? What do you do for a living? And all of that, right? Now, once we have all of that information for each individual identified, we're going to consider the wishes of the deceased. Remember, I mentioned that the nomination of beneficiary form is good to have because it's a guide, but it also talks to the wishes of the deceased. Who did the deceased want to receive a portion of the benefit? We consider that as a factor. We also consider the age, excuse me. My apologies. We consider the age of each nominee or dependent. So in terms of age, in fact, maybe let me just make an example with each factor. So looking at the wishes of the deceased, if you find that there's a person that we've identified as a dependent, perhaps it's an estranged spouse, right? They were married with the deceased, they separated, were no longer on speaking terms for many years, moved on with their lives, but this person is still legally married to the deceased. When we distribute the death benefit, it may not be equitable to allocate a big portion of the death benefit if there are other dependents to this particular person, perhaps because the wishes of the deceased are clear. So following their separation, the deceased may have changed his nomination of beneficiary form and made provision for the new life partner to receive a portion of the death benefit. And that in itself is indicative of the fact that, the prior nomination form included this spouse. That's when they were still together. Things were good. They were happily married. And then they separated and became estranged. And then the deceased changed his nomination form. And that indicates that by removal of this person from the nomination, it indicates that it was the wishes of the deceased that this person should not receive the death benefit. So that can go a long way in terms of determining what portion of the death benefit, if any, such an estranged spouse would receive from the fund. Right? Moving on to the second factor, age as a factor. To my example that you have two children of the deceased, both were financially dependent. One is a major, one is a minor. You have to consider things such as, the major, say he or she is in their late 20s, is able-bodied, can go and get a job, so they can actually, they can find a means to support themselves financially. However, the minor could be still very young, 10 years old, still in primary school, still has 8 more years to go before they attain majority, 8 more years before they may become self-supporting. So for that reason, age as a factor, would determine or require that we allocate more money to the younger one than to the older one because of age. In some cases, it works the other way around, where you may want to allocate more money to someone because of their age, given that they are not likely to be able to be gainfully employed. That's sometimes a consideration where you have two spouses. You have a spouse who's near the age of 60 and one who is still in her 30s, and in that regard, you could say for the spouse who's nearing 60, it's unlikely. The likelihood of them obtaining employment is quite low versus the other spouse who's in her 30s. Then we also consider the nature of the relationship between the parties. And this is where, we look at where these people close, where they estranged. That counts as a factor to consider. We also look at the financial circumstances of each person who's being considered for the benefit. Now, just by way of example, if you have 2 children of the deceased member, they're close in terms of age. One is 30, the other is 32, and you're distributing this death benefit. It may not always be equitable to split the benefit 50-50 between the 2 people. And the reason is that, one could be a qualified chartered accountant who is managing director of an insurance company and a salary of over 2.5 million per annum, and the other one could be unemployed. Unemployed, no qualification, no tertiary qualification, highest standard attained in school was grade 10. Now, looking at those two people, it is clear that the chartered accountant is in a better financial position and also has better prospects going into the future in terms of maintaining that income and in fact also increasing upon that, right? Versus someone who is of a similar age, unemployed, no a track record of employment, no work experience, no qualifications. So for someone like that, their future prospects are not as good as the first person. So we may want to adjust that accordingly. Even though we're distributing the death benefit following the death of their parent, and if you consider the next bullet point, which talks to the extent of dependency, once again, what you would be likely to find in that example is that the one who's unemployed was living with the deceased member and completely financially dependent on the deceased member, while the other child, was living on their own, thriving, doing well, and not have any financial dependency. So that would require that when we distribute the benefit, we allocate more money to the one who was financially dependent, the one whose future earning prospects are not so good. Because as I said earlier on, that we are replacing the financial support that was lost by reason of the deceased death. And then finally, we look at the amount available for distribution. Now, to my example of the two brothers, one who's a chartered accountant and one who's unemployed, if you have a small amount available for distribution, it may actually warrant that you allocate the full benefit to the brother who's unemployed and allocate 0 to the brother who's a chartered accountant. Now, quite often we see this in practice that then the brother who's a chartered accountant will complain and say, I was excluded from the distribution of the death benefit. I wasn't considered at all. But that wouldn't be accurate. It wouldn't be right, because that brother that dependent, because he also qualifies as a dependent, as a child of the deceased, would have been considered for the benefit, but they would have been excluded in the allocation of the death benefit. And this is something that, some boards of trustees miss, that you don't have to completely exclude a person. In order to prove that you followed what was required of you, you did what was required of you as a board of trustees, you need to consider this person. You need to get their information too, consider it, apply the basket of factors, and only then do you arrive at a decision. And then you can say, we are not allocating anything to this person. It's a 0 allocation. In that way, should there be a complaint or any litigation based on that decision, then the trustees will be able to prove that their decision was not irrational. It was based on a proper assessment of the information available, and that that complaint should be dismissed. So the amount available is important, because also at times you find that due to age, the youngest child who needs more money for their financial support before they can be self-supporting, is still very young. So if you're dealing with a benefit of 100,000 Rand and a child who needs financial support for 15 years to go, then that may actually warrant that you allocate 100% to that child and you allocate 0 to anyone else who's in a different position relative to the child. May I move on from the distribution of from the allocation of the death benefit, or do we have any questions? All right, so we'll move
Sorry,
on.
sir. Hello.
Yes, sir.
Yes, you made an example where the deceased member was married, and then there's an estranged wife as a beneficiary, and you indicated that where the deceased has changed the form. What happens in a situation where the deceased went on to marry someone else but did not change the form? The estranged wife is still a beneficiary.
Yeah, that's a good question. I'm sorry, I didn't get your name, sir.
Oh, sorry. My name is Kitima.
Oh, Kitima. Thanks for that. So in a case where the deceased separated from his spouse, they separated from their spouse and became estranged, and the deceased went on to marry someone else. Remember, we spoke about how the issue of whether the second marriage is valid or not, for purposes of 37C, is not a big deal, right? As long as such second spouse can prove their financial dependency on the deceased, right? So when we apply these basket of factors here, so we're going to be applying them against each individual who's identified. So for the first spouse, when looking at the wishes of the deceased, you are saying the deceased did not update his nomination of beneficiary form. But there's still much information that, there's a reasonable conclusion that we can arrive at based on the information available. So we can look at the date that the nomination of beneficiary form was completed by the deceased. So you may find that it was completed while the deceased and the first spouse were still together and still happy, right? Alternatively, it may be that the deceased completed another beneficiary nomination form in recent times prior to their death, but still included that spouse. Now, that, in my opinion, will yield different results for you, because in the first instance, if it's an old nomination of beneficiary form, but the deceased life has changed substantially from what it looked like at the time that he completed that form, then we'd be more inclined to considering the information in recent times versus that nomination of beneficiary form. We know that a lot of people forget to update their nomination forms as and when life happens and their situations change. So if the deceased went on to marry someone else and had other children, but did not update the nomination of beneficiary form, we cannot say that, the first or the old nomination of beneficiary form holds a lot of weight. In the event that the deceased completed a fresh beneficiary nomination form and still included the estranged spouse, that also speaks something in itself. It says the deceased wanted this person to be considered, because even when his life changed and his circumstances changed, he married someone else, had other children, he still wanted that first spouse to receive a portion of the death benefit. And that, in my opinion, speaks volumes. It says he really wanted that person to receive a portion, so we can consider it. We also look at the nature of the relationship. The fact that they are estranged is something that is likely to work against the spouse. But I mean, you can consider other things such as the amount available for distribution. So if you have enough money to cover the financial needs of the new spouse, and still have something that you can allocate to the first spouse, then that's how you should do it. It doesn't mean that a person must be automatically excluded by virtue of the fact that they are an estranged spouse. So there is a PFA determination where the deceased did not have any dependents except for an estranged spouse. And the fund allocated the death benefit to the estranged spouse. Now, some of the deceased relatives were not happy with that decision, and they lodged a complaint with the PFA. The pension funds adjudicator held that the trustee's decision was wrong. They set it aside, and the matter went to the Financial Services Tribunal for reconsideration of the pension funds adjudicator's decision. And the Financial Services Tribunal then confirmed that the deceased spouse qualified as a dependent because the definition of dependent includes a spouse. The fact that they were still married at date of death means that she's a spouse. Their separation and being estranged does not mean that you are no longer married. The marriage is still there, and the consequences of marriage are still to flow out of that. So therefore, that benefit should not be paid to the deceased estate, because according to the deceased family and the pension funds adjudicator determination, the correct way of dealing with that benefit would have been to pay it to the estate, as if there is no dependent and no nominee. But the Financial Services Tribunal confirmed that the spouse, even though estranged, qualified as a dependent and had to be considered by the fund. So we'll still have to consider the spouse, even though estranged, but in considering, just like we do with everyone else, we would have to apply these basket of factors appearing on the screen and see how they score in terms of what should be allocated to them. Does that answer your question?
Thank you very much, sir.
Thank you.
It did. Thank you.
Moving on then to the next slide. So the basket of factors, as I mentioned before, are not found in the Act. They were established through decided cases, and particularly the case of Setole versus ICS Provident Fund. And they've also been accepted, in subsequent decisions of the pension funds adjudicator and the high courts. It's important to note that no single factor is more important than the others. Yes, there is an emphasis on dependency when we are talking about the distribution of a death benefit under Section 37C, but it does not mean that the extent of dependency is more important than everything else. We have to consider all of the factors, together in order to arrive at an equitable distribution. So if you focus too much on one factor only and you ignore the other factors, you would not be making an equitable distribution, right? So for attorneys, who are in practice, who are required to represent clients who may be dissatisfied with the distribution decision, it's important to look at whether the trustees considered all of the factors, and if they did not do that, that's a basis to challenge that trustee decision. Now, it's also important to consider for the Board of Trustees to consider the circumstances of the dependents and nominees at 2 points in time, and that is at date of death and at date of distribution. Now, this stems from the SCA decision in the matter of Funds at Work Umbrella Pension Fund versus Guineri and others. And in that case, what happened is that the trustees made a distribution decision in relation to a death benefit, and a significant portion of that death benefit was allocated to the deceased mother. Now, the deceased mother was someone who was in a frail state. She was quite old also at the time. And unfortunately, she died a few days before the trustees paid that death benefit. Now, when the deceased spouse and children complained about that, the fund insisted that, it was a correct allocation because, they considered all the circumstances at the time of the deceased's death. The SCA arrived at a different conclusion, saying that, the correct time to consider the people's circumstances, the circumstances of the people that you've identified as dependents and nominees, would be at date of death and at the time that you actually make the distribution decision. So things may change. Remember, I mentioned that we receive notification of a death claim. We start the investigation process. In terms of the Act, we have 12 months to conclude this exercise. And, towards concluding the exercise, we send out a letter to all interested parties. And we say, given the information made available to us, this is how we want to distribute the death benefit. Should you have any information that may change things, we're giving you 14 or 30 days to come forward with that information, failing which we will proceed in the manner set out in this letter. Now, things may happen. A person's fortune can take a turn, in an instant. We see stories of people who won big lottery jackpots. So one of the people, to my example about the brothers, one who's a chartered accountant and the other being unemployed. So you may find that initially the intention is to allocate 100% of the death benefit, which is 500,000 Rand, to the unemployed brother, and allocate 0 to the chartered accountant. But, you may find new information which says that the unemployed child won 100 million Rand lottery jackpot. Now that may change things in terms of the distribution decision. Even though at date of death he was unemployed, he had little prospects in terms of gaining wealth, gaining employment, and all of those things. The scale was in his favor that we should allocate the full 500,000 Rand to him. But a few months later, down the line, as we are about to finalize this process, we hear that his fortune has taken a turn, and he's now won 100 million Rand in Lotto jackpot. Now we are allowed to say that now we're changing this distribution decision. We're going back and considering that particular aspect in the basket of factors, that is the financial position of each beneficiary. And now that he has 100 million Rand versus the chartered accountant who's earning 2.5 million per annum, we're saying he's in a better, the unemployed brother is in a better financial position. Therefore, we're allocating the basis on the basis of 80-20 or 100% to the chartered accountant. And this was the principle that came out of this Kenyeri case, to say that a board of trustees should not only limit its view in terms of the financial circumstances of the potential beneficiaries to what was prevalent at the date of the deceased death. Because we have this process that stretches over a 12-month period, a lot can change over that time, and we must consider whatever that has changed by the time we make that final distribution decision. Do we have any questions on that? All right, then moving on to the final step, step 3, which is determining the appropriate mode of payment. Now, the final step is to determine the appropriate mode of payment. And that means that we have to consider the frequency of payment and the recognized methods of payment in terms of the Act. So in terms of frequency, the benefit may be paid as a lump sum directly to a major beneficiary, or it may be paid in installments in respect of a minor beneficiary, or installments to a major where the major beneficiary has given consent that they may receive the benefit in installments, and there should be a written agreement between the fund and such major beneficiary for that payment method. And in terms of the payment methods, in terms of or through third parties, a death benefit may be paid into a trust for the benefit of a beneficiary if the trust was nominated by the member or the major beneficiary, him or herself, or the caregiver or guardian or curator of that beneficiary. It may also be a payment to the caregiver, the guardian or curator, and lastly, it may be a payment to a beneficiary fund. But the third one, that last bullet point, a payment to a beneficiary fund can only be done if the beneficiary is a minor. So we don't pay money to a beneficiary fund if the beneficiary is a major. So that's because a beneficiary fund is intended to receive a death benefit due to a minor child, administer that benefit. So normally they will invest the money so that there's some growth and on that for the benefit of the child. And in between, if there are certain needs that need to be covered for the child, a request may be made to the beneficiary fund to have such an ad hoc payment. In some instances, the beneficiary fund pays monthly payments to the guardian of the child for the child's maintenance, but they hold on to the capital lump sum death benefit amount that was allocated to the child with a view to release that directly to the child once the child turns 18. Now, in our industry, one of the challenges that
Mr. Mothibe, it's Albert Murray. Sorry to interrupt you.
no problem.
A beneficiary fund, who or what is that? Is it one of the retirement funds or a government fund or set up by a curator? Give us an example of a beneficiary fund, please. Thank you.
All right, thank you, Albert. So a beneficiary fund is it's a type of a pension fund, but one that contains exclusively of members who are minors that had a death benefit allocated to them, and that lump sum amount was then transferred into the beneficiary fund to hold on behalf of that minor child, and with the intention to release that that benefit to the child when they attain majority. So they house death benefits that were allocated to minor children. That's what beneficiary funds do. So normally they are funds that were set up by retirement fund administrators and some financial services companies like Fairheads. They are quite popular as an administrator of a beneficiary fund. So a beneficiary fund, unlike a pension or provident fund or retirement annuity fund, it doesn't have members who are people that approach it to say, I want to save for my retirement, I want to pay in money to save for retirement. It only has, the only members that it has are children who have a death benefit that was allocated to them and transferred into the beneficiary fund. I hope that answers your question.
Thank you very much.
Mr.
You're
Matibi, I've got another question following on from that. Would the trustees seek any views or guidance of the child's guardian as to what fund they pay it into? So, for example, I've got a matter where it was paid into the guardian's fund, but there was no prior consultation with the mother and legal guardian of the child concerned.
Yeah, good question. So the requirement is that before paying money to a beneficiary fund, remember, this is still part of the distribution of a death benefit, right? And there is this discretion that the trustees are given by Section 37C of the Act. Now, we know that if a child has a natural parent, then that natural parent is allowed to act on behalf of the child, right? So they could receive a payment on behalf of the child as a general rule. But if the trustees, having considered the information that was presented to them, feel that paying a lump sum benefit allocated to the child may actually not be in the best interest of the child, because the trustees have a fiduciary duty towards the members and the beneficiaries. So they have to protect the interests of the members and the beneficiaries. Now, in this case, the beneficiary is a child, a minor, and if the trustees believe that given the information that was presented to them, the child's benefit will not be used properly. If they fear that there is the risk of the money being misused by the guardian, or perhaps the guardian, given the amount involved, does not have a proper plan or a proper understanding of how to handle the money, then the trustees may decide to transfer that money into the beneficiary fund. But to get to your question, to be direct in answering your question, it is important that the trustees must have cogent reasons for deciding to transfer the money into a beneficiary fund. So they cannot just, as an automatic process, just allocate money to a minor child and then place it in a beneficiary fund. They are not allowed to do that. It has to be something that is done because there are specific reasons to do so. There's a PFA decision on that talks about something similar to that. I don't have it immediately available, but after the session, I can put it on the chat for you if you'd like me to do that.
Thank you. Yes, that would be helpful.
All right. So yeah, it's important that if trustees are to place money in a beneficiary fund, either they get the consent of the parent or guardian of the child, or without the consent, then they must have some valid reasons as to why they are doing that. So normally it would be things such as there's been allegations by other people, interested parties, family members, that the guardian is not going to apply the money for the benefit of the child. Perhaps the guardian themselves has a history of not properly managing money. Someone whose estate has been sequestrated, or someone who has a bad credit profile. At times, even someone's education can be considered by the trustees to determine whether, as a guardian, if you are financially savvy and whether you are skilled or empowered to be able to deal with large sums of money that you will receive on behalf of the child. So the trustees could even go as far as to ask you for a plan. So even if you don't have the qualifications nor the experience yourself to deal with large sums of money, it may be comforting for the trustees if you can at least show that you have a plan, that you have a financial advisor that you're talking to, and once you receive that money, you're going to take financial advice and ensure that you administer the money properly for the benefit of the child. So those are the things that are taken into account in terms of determining determining whether to place the money in a beneficiary fund or not. Before the question, I wanted to talk about a practical concern that we have in practice. So before 1 July 2007, the age of majority in South Africa was age 21. Now, the age of majority was changed from 21 to 18 with effect from 1 July 2007. And now this has created concerns for the retirement funds industry in that quite often we have millions that are allocated to minor children. And, some people have the view that it may not be in the best interest of the beneficiary, although he or she would now have attained majority because they've turned 18, to pay millions of rands to such a beneficiary. So there's quite a lot of instances where some of the family members write to the pension fund itself or to the beneficiary fund to say, how could you pay 5 million rand into my 18-year-old niece's bank account? Ever since you paid that 5 million rand, this child doesn't sleep at home. They are no longer putting an effort into their studies at school. They are taking up substances now. There's a risk of substance addiction and all of that. And this is something that the industry has tried to raise with the regulators and with National Treasury to say, can we have perhaps a special age of majority for retirement funds, so that this money that we have, which we are supposed to look after, which is supposed to be applied for the benefit of these minors. Well, at first they are minors, then they become majors at 18. But can we have a special age of majority in cases like this, so that we don't have to pay the capital sum to an 18-year-old? Can we consider perhaps the age of 21 or 23, or perhaps not even put an age to it, not put a number to it, but to have a provision that says, for someone like that, because there's money available, perhaps once you complete your tertiary qualification, only then may you access this money. Now, there hasn't been any movement in terms of that. It's just submissions that the industry made to the regulators, to the powers that be. But I mean, as you can imagine, it's a little difficult to rigorously push a submission like that, because for the industry, then it is seen as if the beneficiary funds and the administrators are just looking for a reason to hold on for the money longer, so that they can get fees that they earn for administering the money and investment fees and all of that. But it is in fact something that comes from a good place, from the industry, because even when the age of majority changed, I don't think too many people considered this unintended consequence, that now the beneficiary fund receives the money on behalf of a minor, and the minor turns 18. At times, those minors are still in high school, and then suddenly they become entitled to millions of rand at a time. I know that I would not have been responsible with millions when I was 18. But yeah, so that's how we deal with the determination of the appropriate mode of payment as step 3 of the distribution process.
Mr. Matibi, Diane Smart again. I've just got one more question about to clarify regarding payment into a trust. If a deceased member has left a will and they've set up a trust in their will for beneficiaries or heirs in terms of the will, if they're below a certain age, to go into a trust, would it be likely that the pension fund trustees would pay benefits from the pension fund into that trust?
Yes, Diane. So the trustees would consider that because in terms of 37C2A, a payment may be made into a trust if it was nominated by the member. However, it would also be important for the trustees, before agreeing to do that they would have to have a look at the trust deed, to ensure that. So in terms of payments to trust, the one thing that presents a complication, and at times, it may be a major beneficiary or a guardian of a child saying, please pay that money into this particular trust. We cannot do that without first having a look at the trust deed to satisfy ourselves of a number of things. Number one, it would be that once the money comes into the trust, it will be protected. So we want to see who are the beneficiaries of the trust. How are the trust accounts managed, right? If the money comes into the trust and it mixes with other people's money, and other beneficiaries of the trust get to also benefit from this money, then the fund is going to say no to that request. Excuse me. We're going to look at the powers and authority of the trustees. Can the trustees change beneficiaries? Can they bring in other people and all of that? If there is room for anything that may result in the money being applied for the benefit of anyone else, then the trustees are going to say no. Only if this money will be protected once it's paid into the trust and the trustees are satisfied of that, will they be amenable to paying it into the trust.
Thank you.
Thanks, Diane. I will then move on to the frequently asked questions. So can a board of a retirement fund pay a benefit to whomever they want? The answer to that is no. The trustees are required to follow the distribution process as set out in section 37C. They have to follow the 3 steps to identify the nominees and the dependents, and then apply the basket of factors to make an equitable distribution, and then determine the appropriate mode of payment. If the trustees are seen to have failed at any of those 3 things, then the decision that they made would be subject to being set aside, either by a court or by the pension funds adjudicator, because they have to exercise this discretion properly. And while we talk about a discretion, it's also important to understand that courts have this view that it's trite law that if a party has been granted a discretion, only if that discretion is found to have been exercised irrationally, would the court want to set it aside. But discretion is something that has wide application. And you will see if you read some of the court decisions or pension funds adjudicator determinations on the distribution of pension of death benefits, you will see that there's often this comment that it's not up to the court to say we would have liked to see this discretion being exercised this way. The court's duty is to test whether the party exercising this discretion did so rationally, and if they did not consider irrational information, and if their discretion was unfettered. Only then can the courts interfere with their discretion. But to say that I wouldn't allocate 50% to that person, I would have allocated 40 and I would have given the other person 5%, is not what they are concerned about. So if you are acting on behalf of someone who's dissatisfied with the distribution of a death benefit, you need to really find a way to challenge that specific aspect of the duty of the board. So if your issue is that they did not identify all the dependents or nominees, or they did not consider someone who in fact qualified as a dependent, then be clear about that. It's best to be clear about that, and you can challenge the decision on that basis and have the decision set aside. In some instances, if the issue is the allocation of the benefit itself, you need to then be able to prove that whatever that the trustees considered was either irrelevant, or that they were not properly applying the basket of factors. It doesn't help to simply complain about, I'm not happy with the 5%, I think I should have received 10, because the courts don't like to interfere with a statutory duty where, a discretion has been granted to a specific party. The second frequently asked question is, why is the nomination of beneficiary form not binding on trustees? It is not because Section 37C allows them to exercise their discretion, and because the death benefit payable under Section 37C is meant to serve a social function. It is meant to replace that financial support that was lost by virtue of the deceased death. So for that reason, the nomination of beneficiary form is not binding, because we have to consider even those people who may not be nominated in terms of the form. What is the point of completing a nomination form if it's not binding? Well, it's important because it serves as a guide. And we also use that to understand what are the wishes of the deceased, and that's one of the basket of factors that are to be considered when we make an equitable distribution as we allocate the death benefit under step 2. What happens if the board does not distribute the benefit within 12 months? So Section 37C refers to a period of 12 months for the distribution to be completed, but it doesn't set out any penalty. There's no penalty set out for non-compliance. But if your client is not happy that the distribution process is taking too long, you can lodge a complaint with the pension funds adjudicator and, look for, your desired outcome being that you want the trustees to be ordered to complete the distribution process. So that's not completely unheard of. You can do that. But the Act does not prescribe any penalty for non-compliance with the 12-month period. Do legal dependents rank higher than factual dependents? The answer is no. There is no ranking of dependents. And that's why earlier on, I said that it doesn't matter if you're a legal dependent or a factual dependent. What's important is how you score when we are allocating the death benefit and looking at the basket of factors. Is a spouse who's married in community of property automatically entitled to 50% of the death benefit? So we've heard this argument before, coming from some attorneys that, if the spouses were married in the community of property, then automatically the surviving spouse must be allocated 50%. But this is not interstate succession, right? Section 37C specifically says that the death benefit does not form part of the deceased estate. So the law of interstate succession does not apply. And, excuse me, it's also not divorce. So again, we cannot say that the surviving spouse is entitled to 50% of the death benefit. But we have to make an equitable distribution of the death benefit as required by Section 37C. Can a member nominate his favorite charity organization to receive the death benefit? Currently, no. Only natural persons may be nominated to receive a death benefit. But in terms of the Conduct of Financial Institutions Bill, there are some proposed changes which will allow the nomination of non-natural persons to receive a death benefit. What happens if a nominee dies before the deceased member? In that case, then that person will not be considered. If that person dies before the deceased member, then they're out because once again, it's a benefit that serves a social function. And we saw the SCA's decision in the Funds at Work versus Guineri matter, where the court said that we have to consider the circumstances of the potential beneficiaries at date of death and at date of distribution decision. What happens if a dependent dies after the member but before the distribution decision? That's my response to the previous question. Funds at Work umbrella fund versus Guineri, we'd have to exclude that dependent. Can the fund allocate minor beneficiaries' benefits to the surviving parents? No, the fund cannot allocate a benefit that is due or being allocated to a minor child. Cannot be allocated to the parent instead. This is because each person is being considered in their own individual capacity. So the minor's benefit is allocated to the minor. However, in determining the appropriate mode of payment, because we cannot pay money to a minor, we may pay that money to the parent. But the record must reflect properly that that allocation is for the benefit of the minor. We've seen some funds make that mistake to allocate the money to the parent, and later when a claim comes to say that, but you didn't include the minor in the distribution of the death benefit. They want to say, but that was the portion that was due to the minor. We allocated it to their parent. So it doesn't work that way. The allocation must be to the minor himself or herself, and the mode of payment may then be different in that you may be paying to the parent. So that, ladies and gentlemen, brings us to the end of our presentation. I hope that you enjoyed the presentation, and I'm happy to take any questions if you have any.
Mr. Matibi, Diane Smart, I've just got a question about the Government Employees Pension Fund, which is the biggest pension fund in Africa, I believe. I know it's governed by a separate piece of legislation, but as far as you're aware, are the provisions relating to death beneficiaries fairly similar? And does the pension fund adjudicator have authority over the Government Employees Pension Fund?
Okay, thanks, Diane. To the first question, I don't have expert knowledge of how the GEPF operates, but I do believe that it has similar provisions to Section 37C in relation to death benefits. And I do know that they do not, so the pension funds adjudicator does not have jurisdiction over them. So the PFA cannot investigate a complaint against the GEPF. So if you have a complaint against the GEPF, they've recently created an office of an internal ombudsman. Unfortunately, I don't have the contact details, but I imagine it would be something easy to find on Google. But I know that they've appointed an internal ombudsman, and it's someone who used to work at the pension funds adjudicator's office, actually. And if you're not satisfied with whatever the outcome may be from the internal ombudsman, then you may lodge a complaint with the Office of the Public Protector. So complaints against the GEPF are lodged with the Public Protector's Office.
Thank you.
You're welcome. All right, in the absence of any other question, thank you very much for your attendance, ladies and gentlemen. That brings us to the end of our Pension Law 2022 session. Thank you for your attendance. I hope you enjoyed the session. Please don't forget to complete the evaluation forms at the end of the session. It shouldn't take too long. And yeah, thank you very much. Enjoy the rest of your day and the weekend ahead.
Thank you so much, Andrew. It was awesome.
Mr. Mutsi, I didn't get it. Are the slides going to be made available to us?
Sorry, Andrew, the slides have been sent to the delegates via the e-leader platform, and I have sent an email yesterday of with the user guide. So if you missed it, go to my emails, untombi@LSSA Lead, and if you are struggling with regards to getting through to them, please email me so that I can assist you.
Thank you so much. Thank you, Andrew.
My pleasure, and thank you everyone for your attendance. Have a good one. Bye.